Hey guys, today's interview is brought to you by the Kulkarni Law Firm and the Stevens and Lee Law Firm. Our discussion today is the third, apparently, of a series of interviews we've been doing on intellectual property. So if you are in the life sciences and you care about copyrights, you care about patents, you care about trademarks, you probably want to listen in. Today's conversation is going to be about copyrights. Our guest today is the co-chair of the intellectual property group at Stevens and Lee. He recently, along with his co-partner, well, I guess partner is always a co, but with his partner, Mark Anania, was named a leading patent professional by IAM Patent 1000. And I'll put a link for it as well in the what you can see here. So we're delighted to have him. Our guest for today, John Malgin. Hey, John, how are you?
Darshan, great to see you again.
Pleasure. I do want to emphasize you can reach John via email at john.malgin@stevenslee.com, or you can find him on LinkedIn, and that's his long LinkedIn address. He's promised he's going to go change that to be a little bit more readable friendly and rememberable friendly. But you can find him right now as John Malgin Esquire. I promise you there aren't too many of them out there. So he should be easy enough to add. And I know he will be speaking in October at the Scranton Chamber of Commerce as well. So that should be really exciting as well. So John, talk to me a little bit about copyrights. What are they? How are they different from trademarks? Why do I need a copyright when, it's pharma? Shouldn't everything be patents? Like, talk to me a little bit about just what they are.
That's a very good question. Thank you. And so just to level set everyone, last two topics we had were patents and trademarks. So I always say that the three main buckets of intellectual property law are patents, trademarks, and copyrights. And as you mentioned, Darshan, the pharmaceutical industry is hugely involved in obtaining patents, and acts have been passed for the pharmaceutical industry just to allow their patents to last longer than 20 years if they have to go through FDA trials and things. So I'm sure everyone listening to this who is in the pharmaceutical area understands that. Copyrights are ubiquitous as well, and a lot of people kind of pass them over, but they can be very important in every industry, including the pharmaceutical industry. And here's how. Number one, copyrights, and we're going to get back into the details of this, but copyrights cover software. They cover expressions of data, not the data itself, of course. They don't cover facts. They cover the expressions of ideas and facts. But they also cover white papers or technical papers or brochures, the inserts in all of the pharmaceuticals that you buy at the store. Those are all copyrightable, not to mention anything done by employees or outside consultants in the course of working at or for a pharmaceutical company. Anything in print is all covered by copyrights. So they truly are an important aspect of intellectual property in any industry, including pharmaceutical industry.
So let's ask this basic question. You just mentioned that inserts would be considered to be copyrightable. If I was a patent lawyer, if I'm a copyright lawyer and I'm a pharma copyright lawyer, one of the things I'm thinking of is, so is it possible for me to say that if you are a generic company, you can't copy my package insert because that is my copyrightable document? But I've never seen that claim made.
So as I mentioned in the last discussion, it depends. And I hate using that as a lawyer, but it really does. And the reason it depends is you have to look at the content. When you're dealing with copyrights, you have to look to see what is copyrightable subject matter versus facts. Facts are not copyrightable, as I mentioned before. So if there is such a merging of facts into this instruction set that goes with the pharmaceutical product, then you might not be able to protect it. However, the way in which you lay out the layout of the instruction set, the words you use, as long as they're not just facts, all of that information is potentially copyrightable, because in order to get a copyright, there has to be a modicum of creativity. That's the test. And if there's a modicum of creativity and it's created by an individual or a company, and it's beyond just facts, believe it or not, it's copyrightable. So, for instance, you can't copyright the pharmacological chemical a background, a chemical makeup of a drug, right? The carbon chains. You can't copyright a carbon chain. But if you describe it in certain ways and you talk about how to use it and the things you should watch out for, all the warnings in a certain particular way, if somebody copies that wholesale, it's a copyright infringement.
So that's interesting. So what you're saying is the laying out of facts is not copyrightable. However, the expression and the uniqueness of how you choose to express it might be. Unfortunately, in the context of pharma, the package inserts and the package labeling, the format is chosen by the FDA. You follow the format. And that's why it's probably not as copyrightable.
That's exactly right. That's exactly right. So even though this is out of the scope of my practice, but directly in your scope of practice, which is FDA labeling and rules and regulations requirements, that's where they hit. And if the FDA is requiring it, you can't claim that you came up with that format, that look, that feel, that color scheme, those words. If that's all dictated and everyone has to use it by regulation, it's not copyrightable because there's no creativity there.
Interesting. So what you can, however, do is start copywriting your potential ads and your potential expressions associated with that. So the blue pill, for example, I remember, I'm obviously dating myself, but Viagra was famous for the blue pill. That would be trademarkable, but the ad that went along with it, the expression, would probably be copyrightable.
Exactly. That content is, except for what has to be said for the warnings and all that under the FDA, the overall article, the overall commercial, the overall look and feel of that can be copyrightable. So, if I may, I'd like to jump back as what do we mean by copyrightable versus getting a copyright registration? Because that's important here. First of all, I like to always start out with how is a copyright created? It's created when anyone fixes something in a tangible medium that is created, is a creatable work of authorship. And again, it has to be a modicum of creativity. It doesn't have to be big. So what did I say there? It's anyone. So it's either an employee or a non-employee can create something that is fixed in a tangible medium, meaning it's not ephemeral. It's on paper. It's in an email. That's considered copyrightable. You put it down on paper. It's in a brochure. All the obvious ways, the photographs, things like that, are all copyrightable subject matter. And as soon as the person does it, it's copyrighted. Under the Berne Convention in 1988, I think it was, they changed the law and said, look, as soon as you put it down in writing, you can put a C in the circle, say copyrighted, all rights reserved, and either you as an individual or the company. The difference is that in order to go for statutory damages or try to bring someone into federal court, you have to get a copyright registration on that. So you're taking what you created, you send it to the Copyright Office, you pay the fee, it's called a deposit. They look at it, they make sure it meets the criteria for copyrightable subject matter, and they render a copyright registration for you, just like a trademark registration or a patent. You're now recognized by the government to have received a copyright registration in your copyrighted work. Now, who owns it? The owner is either the company or an individual. If you're an employee of a company, the company owns it by operation of law under the Copyright Act. In contrast, and this is what I want the folks listening to hear, if someone's a consultant, outside consultant, a 1099er, they're not an employee of the company, they own the copyright in that work of authorship, and it would have to be transferred to the company that's commissioning them, presumably, to do this software package, this brochure, this ad campaign, or what have you. It has to be transferred by way of a written document, and it has to have the magic language in it that says this is a work made for hire, or it actually has to say this is an assignment of my copyright to you.
So there are several things to sort of tease out from that, right? So I've always thought of the term work for hire to be a broader term used across all IP. Is it across all IP, or is it really intended for copyrights and we sort of all just used it for everything else?
I don't have a lot of pet peeves, but that's one of mine. Whenever I look at an agreement and I see a work made for hire and it's in association with a patent or a trademark, it's really not relevant. A work made for hire is literally in section 101 of the trademark, I'm sorry, of the Copyright Act, 17 USC, section 101, etc. And in there it says a work made for hire is. And it was, we always say the Copyright Act is meant for artists. It's artist friendly. And as I understand, it came about when people were on movie sets and doing things like that, and everybody was contributing to the creative work, but they didn't get any credit for it. So they came up with this plan that said, look, we're going to have you sign something that says this is a work made for hire. We commission you to do this, and we're going to own it. Otherwise, if we don't have this agreement in writing that says work made for hire, you as the artist will own it. And so it's very important for companies and employers to make sure that if they're not working with an employee, no matter who it is, get an agreement in writing before you start the project, or you're not going to own the copyright. Now, you'll own a copy of what they did for you. Like, look, let's face it, if you're paying someone to do an ad campaign on Facebook or on Instagram or what have you, it's presumed that you're paying them to own the ability to use that ad. But as to the copyright in that ad itself, it might still be owned by the outside contractor.
And that becomes really important. For example, if you use a photographer and the photographer takes a picture of someone holding your pill, for example, you might own the ability to use that photograph in your ad. However, nothing stops the photographer tomorrow from taking that same photograph and then using it for another company, potentially even your competitor. So it's important that you get that, you own the copyright associated with that photograph.
Precisely.
What I also think is kind of interesting is what that means is that the language, if you're not a smart IP lawyer, what you're going to have language that says all IP is work made for hire. The truth is it really applies to just the copyrights, and you've now exposed your entire patent portfolio and your entire trademark portfolio to allegations that wasn't covered because that wasn't part of the language. So exactly. You basically have to now come in and say the copyrights are covered as work made for hire, but everything else is assigned as appropriate or licensed as appropriate to basically the company you're working with.
That's exactly right. So when you look at these IP transfer agreements, it's got to have that magic language in it that says, I like to do this. I like to say, look, everything's assigned. You hereby agree to assign and you hereby do assign in this agreement anything you create intellectual property wise, patents, trademarks, copyrights to company X. Certainly you can throw in the added words of, and if it's copyrighted work, it's a work made for hire. But the assignment trumps a work made for hire. Right. So to me, it's better to just assign it. And if it's strictly a copyright, you could say there's a work made for hire, and you hereby do agree to assign and do assign over to us. So you catch it both ways.
It's interesting, and this is sort of getting a little bit into the something you and I said we'll probably do as a separate talk in the future. But I remember there being a court case on I agree to assign versus I assign. What is the difference and why does it matter? Just for people who are listening and going, oh, here's a little tidbit.
What's the difference, right? Yeah. So the difference is in an agreement, if you really wanted to, split hairs here, agreeing to assign something is saying, okay, yeah, I will agree in the future, but you're not really buttoning up the compensation, the consideration in that. And so if you start out as an employee at a company, and I don't know which states are which, but some states will not consider continued employment as enough consideration for intellectual property that's been created during the employment, such that a year from now, if you say I agree to assign, and then I create something as potentially patentable, and then you don't give me anything for it, I might say, well, I agreed to assign, but now I don't. So unless you paid me $1,000, I'm not going to. And that's been held up sometimes in court to be appropriate.
So let's go back to the basics, and today's conversation is copyrights 101, if you will. So we've used this term copyrightable. Like we all know what that means. And I'm going back to my law school days, and I'm old, and that's when the dinosaurs roamed the earth. But when the dinosaurs did roam the earth, I remember copyrights being referred to as a bundle of rights. So what is in this bundle of rights? What does that even mean?
Wow, that's great. That brings me back to as well. So a bundle of rights, what does that mean? So a copyright, when again, let's talk about it. You have a common, I don't want to say common law copyright, but you have a copyright since it's fixed in a tangible medium. And that bundle of rights is associated with it, whether you got it registered or not. The one difference between a registered copyright and non-registered copyright is if you were to go for damages for copyrights and it's registered and the infringement occurred after you got it registered, with one exception we're not going to get into today, then you can assert statutory damages of up $50,000 to $150,000 per infringement without having to prove actuals. So that's why you want to go get a registration. Plus, there are courts that say you have to have a registration as your ticket into federal court. Now, there's some question about whether you need that or not, but get the copyright registration early on important documents. Now, the bundle of rights is the right to copy, the right to make a derivative work, the right to publicly display, the right to use. So that's the bundle of rights. As soon as you have a copyright in something, that's the whole point. Like, you going back to your photographer example, which is an excellent example. You know, you say you're lucky enough to get married, and you go to the photographer, he or she sends you the proofs. It says proofs in the background or on your face, it's superimposed. And you go, we like those. We'll get those 10 pictures out of the 100 you took. Okay, great. They send them to you without the watermark on it. And you say, thanks very much. And then you go to Walmart or Walgreens and you try making copies and you can't. Why is that? Because guess what? You own that physical copy of that photograph taken by the photographer of you and your spouse, but you don't own the copyright in the work. And you have to go back to the photographer and obtain the copyright ownership as well as the physical thing. Even in a fine work of art on the wall, you don't own the copyright unless you bought it from the artist. So that artist, nowadays, not to get too far-fetched here, but nowadays people can do NFTs with their artwork. And they can continually make money off of one beautiful painting that they did continuously. So there's a lot of, bundle of rights. Great thing for people to look into and delve into deeper, and certainly can reach out to me if they want to talk more about it. But it's becoming more and more important how valuable that bundle of copyright rights are once you get a copyright in something.
Which is really interesting, because you talk about derivative rights, for example, and Pharma is rife with this issue, which is, and I'm going to again step into a topic that I think we probably need to do a separate talk on, but because we've done so many of these individual ones, it's now fun to start combining concepts. But the one thing I think about is Pharma ads are so commonly made fun of, and it would be so easy to take a ad for Cialis or for Viagra and make fun of it. What right can you, as a copyright owner, come out and say, no, you can't make fun of my Viagra ad because I own the copyright to it? And I already see you sort of wanting to talk about it, so go ahead.
Yeah, and I'll try to be brief because this is going beyond 101, copyrights 101, but it's a great area. Because everything in intellectual property is about, who owns it, what is the property, and what can you do to protect it, and when is there excuses or defenses to not being able to assert your rights, right? So in the copyright world, just like you're saying, if somebody goes and tries to make fun of an ad, it's going to fall into probably the category of fair use. They're making a parody or they're goofing on it. They're not trying to take away your copyright rights and displace what you would have gotten because of the ad that you placed for Viagra or Cialis or whatever. But they're rather just doing commentary on it. And so there's a fair use defense in copyrights, and it's a strong one. There's one in trademarks, not as strongly used, not as used often, but copyrights, again, that's codified. You can look it up in the Copyright Act. What is fair use? But some of the elements are if it's for educational purposes, if it's used by an educator, if it's used for political or critical commentary, if it's not for commercial use. Those are all elements for fair use of a copyright. So I would gather, and again, we're not giving legal advice here, but I would gather that your example would probably allow someone to goof on those commercials if they're doing it for even entertainment purposes, maybe. But if they're getting paid, if there's commercial factor coming in, then you got to start being careful. But like Saturday Night Live does parodies all the time on all this stuff, and
right.
It's kind of protectable First Amendment speech and a defense that usually stands up, because you're not trying to displace somebody. You're not trying to do the ad to goof on Viagra to sell more Viagra.
So the sale, the connection is, it doesn't have to be commercial in that you're trying to sell Viagra as a competitor, but it can be commercial in that you make money off of it still. So Saturday Night Live obviously makes money off of the situation.
They make money, but it's so far removed from the actual original copyrighted work that it's transformative, and no one. Again, it comes down to by me doing this, making fun of your commercial, am I displacing the value in your copyrighted work? Probably not.
So this would be the difference of Saturday Night Live making the commercial versus, say, a Cialis making fun of Viagra.
Exactly. A whole host of things come in there we're not going to get to, but it's unfair competition, false advertising. I have a client who does outdoor living things, decks and fences.
Sure.
And they take photographs of their privacy screens, for instance, sometimes. And somebody just wholesale takes that exact photograph and uses it for their privacy screens.
Right.
So you can possibly go after the infringer for trademark infringement or design patent infringement or what have you, but you can also go after them for copying the photograph. That's either the actual copy of the photograph or a derivative work, unauthorized derivative work of that photograph in their ads. They're obviously doing it to sell their own privacy screens. And so that we've oftentimes taken that approach.
So here's another question. We talk about intellectual property being a quote unquote property right. Now, when we use that term property right, does it mean the same thing as, say, a ownership in real property, or comparing it to something like privacy rights, where people are like, do I own my data? And I feel like, and I'd love to sort of, I don't know if this is, again, I feel like this is copyrights 102, if you will, 104. But are these rights, are these intellectual property rights in general the same as real property or like privacy rights or data rights?
You're forcing me to say it depends again. But it kind of depends. Like, a copyright, and this is always a controversy for patents too. Is it really a property right or not a property right? Sometimes it gets political as to how they're going to defend it and enforce it and all that. But, a copyright right is, it's really the right to stop others from literally copying what you've created, as long as they had access to it and you can tell they copied it or it was substantially similar to yours. It's really a way to encourage people to create. I mean, look, like I said about patents, it goes all the way back. The copyright concept goes all the way back to it's in our Constitution, the United States Constitution. It was to protect map makers. And so, because it took forever for people to draw out maps by hand, and then people would just look at those and literally copy them. And so they said, right, you can't do that. And so is it a property right? I guess not necessarily. Like, privacy is a whole thing. Privacy and the right of publicity are things that came up through through jurisprudence.
Right.
And right of privacy is a whole other thing, but right of publicity is similar to copyrights in that now it's about the person or the thing that has a right in their face, their likeness, their sound, because that's what they use to make money. And if somebody displaces that by copying their sound, their character, their face without their permission, you're displacing their ability to make money. So that's kind of a personal property right in themselves. Privacy really comes out of something else. That privacy comes out of the sacrosanct of privacy and the right to be left alone and not be invaded. And that has extended, as you know, because we've dealt with this, to beyond our wildest dreams, to data and health data and privacy data and everything else. And I'm not going to go in that area today.
Fair enough. So, but you raised this concept that I think it's important to at least tease out a little bit more,
Sure.
Which is the right to of publicity. Is that the same thing as the right of owning your own copyright? Like, and the reason I'm going to tie this in is I'm thinking of the whole Michael Jordan in China issue, where he had to spend a lot of money defending, for example, his trademarks. I didn't hear much about him defending his copyrights, but I don't know if he has a copyright to anything in China. And how is that the same issue we're talking about?
Yeah, well, now we're going to copyrights 404, international copyrights. But yeah, in the United States, I can talk to that. Is it the same as a real estate property? I always use the analogy of real estate when I talk about intellectual property. So, it effectively is right for people not to walk on your property unless you give them a license to do so. Right. Say you look at, I always look at a piece of property on the corner of a major intersection near a beach and it's vacant, but no one's allowed to use it because you own it. But if you want a hot dog vendor, and this is actually a case, it's not a litigation, it's real. It's in Seabright, New Jersey, near where I live. There's a lady that used to put her hot dog cart on this little corner of this property. Well, it turns out she owned the property. She was a millionaire. She was selling her hot dogs. But if somebody else tried to do that, you can keep them off. And similarly, if you've created something, right, it's now property. And to me, I would say that copyrights are a property right, like real property, because you can stop people from copying it, making a derivative work, all the bundle of rights we talked about. So right up. Publicity is the same thing because it's only, Elvis was only Elvis, right? You can't recreate another Elvis. But people started copying things with Elvis's image. And guess what? His wife, after he died, made more money protecting that for the estate than they did for his albums and his movies.
Huh. It's interesting that there was a recent movie on Elvis. I don't know if you watched it.
I didn't watch it, but I look forward to watching that.
Yeah.
Did you watch it?
I did. With Baz Luhrmann, he's the director. And again, it's a really nice movie. But what I thought was interesting is his agent owned a lot of I want to say he owned several of the copyrights, if not more.
The Colonel?
And I'm sorry?
Was it the Colonel? You mean the guy that
the Colonel? Yeah.
Yeah, he was horrible. In my opinion, he was horrible, but he's passed, so I can't get sued for defamation. But here's why. He owned almost more than 50%, or I think he owned a lot of Elvis's creative works.
Right.
His recordings, everything. And he said, don't worry. And, poor Elvis didn't know what was going on. And then he finally realized that this is played out multiple times in the music industry. These poor musicians and artists have agents and managers that try to help them get where they're going, but they end up owning these intellectual property rights that the artist usually in the beginning doesn't care about. They just want to get their artwork out, their songs, their music, their literal artwork, pictures, all that stuff. You end up finding out that that's more valuable than the artwork itself. Sometimes is the copyright value in it, or, whatever, the trademarks. For instance, Bruce Springsteen just sold to Sony the publishing rights of his songs for $500 million, $500 million.
Right.
He originally didn't own them. He had to fight CBS, I believe, his first contract, because they own his publishing rights. And back then it mattered. Back then, you could have a song, you could own the copyright and the underlying musical composition, so the words and the lyrics and the chord structure in that song, but it was the recording that everybody was buying.
So it's kind of interesting because this has popped up recently again in the context of Taylor Swift. And I find it fascinating that we started with talking about Pharma, but we're talking about Taylor Swift right now.
I'm trying to bring it back to Pharma. I don't know how, other than to do a bad joke about Elvis and how he died. So I won't bring that up.
We won't go down that path. But what I think is interesting is, two things do pop up for me, but we'll go down that path in a second. And we're already past time, but this is such a fun conversation. Taylor Swift, I remember she made a huge deal about the fact that she doesn't own the rights in her songs. And she went to try to buy them, and they were like, we're not selling. So what I've heard she's doing is she's re-recording all of her songs, re-recording all of her master copies, I guess is what they're called. But if that's true, wouldn't that just be a derivative work? How would she own something that she's already sold, even if she's making another copy?
So that goes back to what I glossed over before, and it's something that's a very good point you brought up. That again, it goes a little bit beyond a basic course in copyrights, but and this is the distinction. The distinction is when you create a song, you have the words, the lyrics, and you have the music. So you as the artist, again, as I mentioned before, unless you're an employee of a recording company or an employee of some company where they're going to say they own it, you did it as a work made for hire or as an employee under operation of copyright law, usually you as the artist own the words and the music because you created it yourself. You're the original owner, the original, you're the creator of it. And usually you go and you copyright that. No big deal. Then you go and make a recording of it, a phonograph. It's the phonograph, it's that recording that is equally separately copyrightable or owned by somebody else. And that's what happened here. She, like a lot of artists, made a deal with a studio that said, all right, I have these songs. I'm going to record them at your studio. You're going to front me all this money. You're going to pay for the distribution, advertising, marketing. And because of that, I'll get a percentage whenever you sell an album or a record. But I won't own that recording. So what she did was, I own the copyright in the words, in the music. I'm just going to go re-record them. And by re-recording them, it's a new record of her own copyrighted work. So it's not a derivative work of their recording. It's a derivative work of her, or it's actually not a derivative work. It's a phonograph or a recording, musical recording of her lyrics and her music, her chords. So she doesn't owe them a dime unless she has some agreement that I'm not aware of that says she has to, pay them for it. But like, I see what you're saying. You think it's like a derivative work of that recording, but it's a whole new created recording, not using the other recording. So it kind of gets into technology versus law, but you're basically severing any ties you had to that the master tapes or those recordings, which in and of themselves get a P in the circle. They're copyrightable as well. So you record the musical underlying composition and the lyrics, and then you also can record the recording of that. And so you can get a combined copyright, but you can also get separate ones, and that's what she's doing now. She's re-recording it all, so she doesn't owe anything to the recording company or her agent that bought it from them.
So, which is really interesting, right? Because what you've now got is a scenario where you have two copies of the same song. You could go buy it from Taylor Swift, possibly and probably for a higher cost than from the bootleg Taylor Swift, for lack of a better term. And all I see her doing, and again, this is as a lawyer, do you see this as a price to the bottom, where now they just have to compete on price? Because from a pure artistic standpoint, they're both Taylor Swift both Taylor Swift albums.
I don't know where this will go, other than to say that certain fans are rabid, and she has rabid fans.
Yes, she does.
And they will probably be loyal to her and go buy her versions versus the big bad studios version if she says so.
But what would Spotify buy?
What's that?
What would Spotify buy? Good
point. It really is leverage. Does she have the leverage to stop them from using her underlying composition and her lyrics and her chords? Probably not, if they were already done, and she probably agreed to allow those recordings to occur. So now she can't do anything about those recordings. So Spotify, if I was Spotify, I wouldn't want to get into a litigation. So I'd think about that for a long time, who I'm going to buy from, or I'd put them both on. Let people decide, unless the company that she was with says, no, you can't do that. It's all coming down to leverage, right? But I would put them both on. Now, I'd be remiss if I don't talk about this, Darshan, in this context, because now we're talking about music. There was something called the mechanical rights in copyrights. It came about because of the pianos, the pianos that play by themselves, self-playing pianos.
Yeah.
And they had these rolls on them, and people were copying those rolls. Long story short, Congress passed a law that said, look, we're going to have these mechanical rights, which means if someone comes out with a song, you really like it, you want to record it yourself, you can without getting permission from them. You just got to pay them these royalties, which are set by Congress. And they have a whole group that sets the royalty rate. I don't know what it is now. I apologize. 7.5 cents per record or whatever. But it's really cool because if you notice, like the most re-recorded song is "Yesterday" by the Beatles, Paul McCartney.
Okay.
He gets royalties from everybody, and he doesn't have to cut a deal with them. He goes through a service, Harry M. Fox or somebody else. But long story short is that's allowed in the Copyright Act for people to make recordings of someone's song without getting permission, as long as you pay them those royalties, those mechanical royalties. And it's called mechanical because it was a mechanical device that ran the piano.
So I'm allowed to make
everybody out there, I'm sure, but you and me.
Just to clarify, what you're saying is I'm allowed to re-record and create my own versions of songs.
Yes.
As long as I pay a licensing fee effectively to the original artist.
Yes, per recording or per purchase or
whatever that term is. Yeah.
And there's a little bit of moral rights in there now. Like it can't be a disastrous version. Then you can go and try to stop them because of moral rights. But again, that's beyond the scope of this discussion. But it's important to know that if you're trying to do your best to record a song, no matter whose song it is, yeah, in the United States, you can do that without getting permission first, and then just paying the royalties. I've heard Sting say, every breath you take. So many people have recorded that and played it and all that stuff. Now, keep in mind, this is funny. That's a bundle of rights, but you can't publicly play a song without getting permission. So people can record the song because of that exception of mechanic rights, but you can't go on stage and play it unless you give a public display deal to the people so in other words, I record an album and I want to go on tour. I may not be able to play those songs unless I pay another fee for public performance, which is through another organization called ASCAP, Seascape, or BNI. So there's these bundle of rights, and then there's these companies that follow along. I mean, one of the things I wanted to do when I was coming out of college and stuff was to be a person that worked for like ASCAP and go into bars and listen to all the songs and write them down. And if they weren't on the license list, I could literally send them a complaint and say you just violated this artist's right of public display or public performance. Believe it or not.
But so, how do you even prove that though? He just goes, no, I didn't.
So the agent went in and wrote down things and testified that they were playing these songs. Now, how do you get around that? You pay ASCAP a monthly fee for licensing of their library, of their catalogs, and they have 10,000 songs. So chances are you're not going to have a problem. But they were doing that to enforce. They were enforcing the license and strong arming little taverns everywhere. So it's crazy. But I just want people to know, like when you play a radio at your house, no big deal. If you play it in a bar, it's a different story.
And it's actually similar to something that I've personally experienced. I had a website designer design my website and use images, which I assumed were properly received. I got this. I had Getty reach out to me years later and said, "You're using one of our images, and we expect payment."
Yep.
And I was just like, first of all, I didn't design the website. Number two, I don't know what you're talking about. And the image you're talking about is this tiny little sliver of the entire image. So it should constitute a different work. In the back of my head, I kind of knew derivative works is a thing, but I was curious if it could pass. And they're like, no. Your website designer has used this. Here's a screenshot of it, and you owe us money. I ended up actually paying and settling and all that good stuff. But it's the exact same process, which is they were in the business of going and finding the images, which I assume have some version of the logo or something in there, or some digital thumbprint that they can find. So is this the equivalent of what you're talking about?
Absolutely. Absolutely. It's the exact thing I'm talking about now. It's an imaging. And there is a cottage industry, or maybe it's bigger than cottage industry now, of scraping the internet through bots, robots that now don't need words. They can actually look at images and analyze images to see whether or not it matches anything in their catalog. And then they go out and send the letter of you're infringing, pay up.
Yeah.
And Getty is one of the largest content providers of images on the internet. And as long as you go and buy them, they're not expensive, but website folks, for whatever reason, don't do it sometimes. And so word to the wise, when people listening, and especially in pharma, when you're having somebody create for you, make sure you get them to prove to you that they're getting all of the images through Getty or some other resource like that. And get indemnification that if they don't do that, they have to indemnify you if something like this happens.
Which raises a couple other points that I want to raise before we are so far. We already passed where we should be, but this is
happens
always
every time, right? You didn't realize how exciting the world of IP is.
I've always loved the world of IP. But let's talk a little bit about this. One of the things you mentioned was this idea of moral rights. And I recognize we don't want to go down this path because it can get really fun, really complicated, really quickly. But what really shines out to me was Roseanne Barr singing the national anthem and how she did a terrible job at it.
Yeah.
And on one hand, I'm kind of going, well, if someone had the copyright to the national anthem, they could enforce it. But then I had the second thought of IP ownership of federal property and how that gets played out. Do you want to talk a little bit about those two issues?
Well, yeah, it happens in trademarks and in copyrights. I'll give you an example. This is where they all come together. If I file a patent application and the patent office issues the patent application, I can't claim ownership in what I wrote. My inventor cannot claim ownership in the patent drafting. It's because it's government. It's part of the government. The government published it, and they said anyone can use copies of whatever we have in here. They can't copy the invention, of course. But so that's a kind of neat thing. Roseanne Barr, that's kind of like moral rights. But yeah, there's something about, when government owns things, you basically gotta get a license from a reasonable royalty license from the owner because it was public funds. A great way to remember moral rights for me, and what I teach my folks whenever I'm giving talks on this, is the Monty Python case. Monty Python, as you and I know, but probably younger generations do not, but it was a great comedy group. Had very funny skits and episodes. Anyway, they would put on a 30-minute show in England.
Right.
Uninterrupted. ABC bought the rights and brought it here to the States. ABC had to pay for it, so they put ads on. They cut out, let's say it was an hour show, they cut out 15 minutes for ads. And they might have cut some of the portions of the Monty Python skits. Monty Python sued for moral rights, saying, you can't do that. It's not the same if you're cutting portions of our show out. It's not funny anymore. And they won.
Wow.
Yeah, so that's like moral rights is like you're chopping this up, like you said with the Roseanne Barr thing. You're chopping the song out so bad, you're ruining the whole copyrighted creativity of it because you're making it horrible. It's not a classic derivative work or a respected copy of the song and re-recording of the song. You're bastardizing it. You're making it unpleasant. So we can assert our moral rights against you doing that.
So is it important when you get work for hire to insist that includes moral rights?
Yes, it's in every agreement that I write. Whether it's enforceable or not, it's in there. So we'll fight it later. But yes, you got to have a right over that. I mean, artists are always talking about their ability to have creative control, blah, blah, blah. Moral rights is like a classic term that we put in to any time there's a connection between parties that are going to do copyrightable works.
That's fascinating, because I've read 1,000 licensing agreements, and they usually just sort of have your boilerplate on IP, but I've never seen this idea that the work made for hire includes moral rights. So you don't get to come in and say that re-editing was a violation of my moral rights. So even though you own the IP, you don't actually own the right to edit the IP in a different way.
Yeah, well, I mean, if I'm the artist, I'm going to ask to keep the moral rights. If I'm the owner and saying to you, this is a work made for hire, I want you to create for me, I want to own the moral rights, so you can't come after me and say you can't chop that up. And to be honest, I believe moral rights were not really enforceable years ago in the United States, but now they have become. And I'm not sure when that happened. I'm not sure which revision of the act, but I think moral rights were not always considered to be protectable here in the States, but that's changed since we aligned ourselves more with Europe and with outside the United States.
So let me take this to bring it all back together.
Yes.
As the last question. And believe me, I have so many more I could go down. Like I'll give you a question I wanted to ask, but I'm not going to go down, which was the LexisNexis case and how Lexis claimed that they had a right to court cases, for example, and
shepherdizing
and stuff like that. And I forget where this decision went, but I remember the whole argument was it's publicly available information, it's federal information, state information. You don't get to exert a right on it, but Lexis was. So it's our expression of it is what's being protected. So that's a question I really want to go down. But the other question I want to ask, tied to pharma, is the question that I've been involved in cases associated with this, but I'd be curious what your take is. Standard operating procedures. Pharma lives and dies by standard operating procedures. Do I, as a pharma company, get a right to exert a right over my standard operating procedures? Can someone else copy my standard operating procedures wholesale and say, these are just facts, they apply to my product just as much as they apply to yours? You don't get to tell me that this is a standard and therefore only you own it.
Only if they copy the expression. So that kind of gets close to ideas versus expression dichotomy. If the standard operating procedures are ideas that are not creative other than in the way you arrange them, but they're still ideas, it's going to be tough to argue that they stole your copyright in that. But you could say they stole your know-how or your trade secret if you don't let them out. But you're right. This is again where copyrights meet ideas or expression meets idea. And it's tough to argue that if, standard operating procedures, for instance, when you're making something in a vat, you have to look for the hot spots and all the stuff and make sure you do this, make sure you do that. When you blend it, FDA regulations, all that, it starts becoming factual in nature. But if they wholesale just copy your brochure or your standard operating procedure manual and don't change anything other than their name versus your name, then you could go after them, right? Possibly. But you're right. It's picking out the facts and almost having it the same, but changing it a little bit might probably get them around you suing for copyright infringement. I use this example. I use this expression called "scenes affaire," and I don't know if you've heard of it, but "scenes affaire." And I was hoping I can get it into this session because it's kind of French. "Scenes affaire" is. I'll give you an example. A car chase. In any movie or any show, you can't say that somebody ripped you off because they did a car chase in their scene. And I did a car chase. So say it's two detective series and one does a car chase. I do a car chase and I say, hey, you copied my car chase. Now, if they copied the look of it so much so and all the angles of the cameras and the cars that were used and the where they did it, what city was in and what streets they used, then you could argue, hey, you're copying my actual car chase, not just a scenes affaire, which means a scenes affaire is the car chase is in a lot of detective.
The concept of car chase.
Right. So standard operating procedures, you need them, but you don't have to copy mine. You can make your own up. If you like our facts, you can copy them. And if they have to be in the same order because it makes logical sense to be so, because they're SOPs, standard operating procedures, fine. But if you put them in the same order and look the same, use the same font and everything else, and the borders and all that other stuff, you don't need to do that to have a standard operating procedures.
It's interesting, the sans affairs concept, because this is probably, I'm a huge movie buff, in case you can't tell, and one of my favorite fact is that you land up seeing the same themes over and over again. And so I remember that at one point, I want to say like 2013, 2014, there was the movie Taken, there was the movie like Mission Impossible, and then there was like James Bond, and all three of them had scenes of the main character running across the roofs in like Turkey, because I guess it's a really scenic spot to do chases. So it reminds me of exactly that, where all three of them, whoever the guy or the woman was who found locations, probably thought this was a really cool place and probably worked at 3 different places. But you just had the main character running through like clothes and stuff being dried. And I assume the argument there could be, this is past scenes affair. But it's sort of an interesting concept that it's not just a car chase. It's a concept you could, running through clothes is probably okay. Running through rooftops is probably okay. Running through the same rooftops across Turkey, you're pushing it at that point.
You're pushing it, yeah. Yeah, absolutely. Because you might be taking from the copyrighted work such that people, we're not talking trademarks here, but they might go see your movie because they saw that in the coming attractions, but you're the one that created it first.
Right.
By the way, we're not going to talk about today, but architectural structures in those movies are copyrightable too.
Is that right?
Yeah. So you have to get releases from the buildings, any artwork that's in movies. There's a lot of releases you have to get when you do movies.
I thought, sorry, can I ask a couple more questions then?
Yeah, absolutely, yeah. I got all day.
It's so fun. But one of the things they always talk about in photography, for example, is if it's done in public, you don't need a copyright release because it's public access or public use or whatever it is. First of all, how true is that?
Person? Like if a person's walking down the street or something?
Yeah, you don't need a release of the person because they're walking down the street in public.
Yeah, because they have no expectation of privacy.
Right.
And if you're I take a picture of Brad Pitt in the street.
Yeah.
That's okay if I'm using it in a news article. But if I take that picture and I advertise a car with it, he can sue me.
Interesting.
So, yeah, because you're using it for commercial purposes. You're not just using it because he was out in the street and it's for news. You basically got a picture of him and now you're going to use it to promote or endorse or influence something. Not good. So so I don't know. You're getting so buildings are in the public. So why can't you just?
That was a concept.
I think it probably is. Now I'm going to get cynical, but the architect lobby probably said to Congress, "Hey, this isn't cool. We have rights in these in the architectural plans that built these buildings, and these buildings are in and of themselves copyrightable subject matter and protectable, and you can't just go ahead and take a picture of it."
Fascinating. And that may or may not be true. We don't know, but it's something you want to protect. Another concept I've heard, and I collect a lot of art, and a lot of art I tend to like tends to be more modern art. Nice. And one of the things I tend to like is a commentary on current culture. So it might be, I'm making this up, but it might be like Superman smoking a cigar, for argument's sake. That sounds like a fascinating thing. I've never seen anyone do it, but that sounds fascinating to me. But let's say that's what it was. I could totally imagine DC Comics coming in and saying, you can't do that because it's my character. And when I talk to artists about this, I can't tell you how many artists come back to me and go, oh, no. I do no more than 3 of these images, so that's fair use. And I'm going, first of all, I don't remember fair use having a number. And number 2, even if they did, based on my conversation with you today, I'm going, that might have moral right implications because Superman smoking a cigar may not be what DC wants Superman to do.
Yeah. Yeah. And I don't know whether it's through copyrights, but it could be, but it also could be through trademarks. Yeah. That's what I'm thinking. Cause you can trademark a series. You can't trademark a title of a book, but you can trademark if it's a series. We talked about that last time. There's probably something you can do about it, unless, again, it's commentary on, the society and how people are Superman, but then they smoke and then it's not good for them or something like that. If it starts going down that path, you're going to have an issue trying to fight it because it's criticizing something and using Superman to do so. You're not endorsing, Superman's not endorsing this, doing that. There was something else you mentioned.
But this three pieces, this argument that, no more than three.
Oh, yeah. Those are all, in my opinion, I want to say old wives' tales. They're
Right.
They're old lore. The classic one is, well, I only used 8 bars of the song, so I'm good, right?
Yeah, exactly.
I mean, I don't even know where they came from. It probably came from a case in 1920s. I don't even know. I got to be honest. I apologize to the audience, but it's not right. It's the old thing with the invention. You put it in an envelope and mail it to yourself. These are things that just come about from folklore, and it's I have to tell clients, well, let's talk modern day. Website people that are on the internet say to me, and your website designer probably said, oh, it was on the internet, so I just took it off. Like, what's the problem?
Right.
It doesn't mean that if it's on the internet, it's not copyrightable. It's not copyrighted or owned. There's not a copyright registration in it. And obviously Getty told you that it was.
Right.
So there is a requirement that you should put a copyright notice on things so that people can't claim innocent infringement. But even if you don't put the copyright symbol, you can still stop people if you can prove that you own the rights in that copyrighted work. And so there's a lot of, Wild West going on in the internet that, not until it's enforceable do people realize, oh, I better not do this. And now with the technology, scraping probably videos too, but scraping images without having to have any type of words to flag someone has created literally a cottage industry of copyright attorneys with probably a group of paralegals sending out these cease and desist letters and saying, pay up $750 and we'll go away because you just violated our client's copyright. So they'll learn.
So it takes, again, tying it back to pharma, something that I can totally see happen. Let's say I'm Kim Kardashian, and Kim Kardashian got into trouble a long time ago, and it's like the big pharma FDA moment where we all got to talk about Kim Kardashian and it'd be totally legit. But in that specific instance,
I have to say, near and dear to my heart, she's Armenian descent as well as I am. Maljian,
okay.
Kardashian. All right, go ahead.
But the idea here was Kim Kardashian did a pharma ad, and it turns out it wasn't appropriately vetted, and FDA got the company into trouble, and they had to do like a whole fix-it kind of situation. But now I'm sort of thinking about influencers in general, and companies are going and saying, we want you to talk about our product, which is great, and these are all the good things. In fact, because of this, Juul landed up having to, Altria, which owns the company Juul now, which makes the electronic cigarettes, got into some serious trouble. And they may land up closing or whatever it is. I don't know the specifics of it this second. But Altria took a 70% cut on the acquisition as of last week. But the point being, I wonder if these Instagram celebrities or these influencers who are often walking around talking about whatever they're promoting that moment, they need to start looking at getting releases from the buildings and from the Louvre if they're in the middle of the Louvre, because it's right now no one's noticing the guy who has 4,000 people following him. But if you're Kim Kardashian, every single piece you do has millions of followers, and it has significant commercial value. Do Instagram celebrities need to be aware of these types of copyright issues, or is ignorance a fair sort of don't need to worry about fair use argument?
I mean, as an attorney, I would say ignorance is never an excuse. You could say you're an innocent infringer, so you don't have to pay the premium for willful infringement, but you're going to be liable if you violate someone's rights, whether you knew it or not. If you're in business and you're making money, that's when people will start waking up, like you said, when you get a bigger target on your back. So, the influencers. I don't want to commentate on daily life these days, but everyone wants a quick buck and they don't want to do anything for it. And most of the time it's okay to do that, right? But if you get to be an influencer of 100,000 people looking at you, someone's going to notice something that's not right and come after you. So yeah, get if you're gonna talk about a product, get the company to you have them sign a waiver, or that they're responsible for when you're using their product. Anything happens, you're not responsible as an influencer, but you may not have the leverage to do that, right? So it's pretty much ad hoc these days. Everyone's just winging it, and until someone comes along and tries to assert their rights, no one's going to care. It's about the risk, right? But to your point, I'm sure Kim Kardashian has a team of people clearing whatever she can clear before she does anything, because every time she promotes something, it's $1 million in her pocket.
Which is interesting. Now I'm thinking about, as you put it, moral rights. I'm thinking about the right to edit, for lack of a better term. And I'm thinking, my house was built by an architect. Do I have the right to put up a new wall and change that, or is that a violation of the architectural plans?
I don't know. It depends, I guess. It depends on, what the architect had in his or her plans. Do they have a limitation on that? I've never seen that. I've never heard it. But I bet you if it's a famous piece of architectural work and the architect treated him or herself as an artist in addition to being an architect for some famous building in New York, I bet you if you started changing things, they might come down and say, hey, you can't do that. These are my plans, and it was built to these plans, and I have rights in that. That's probably the context.
Frank Gehry could say that, for example.
Who's that?
A Frank Gehry, who's like a huge famous architect, could come back and
like Frank Lloyd Wright. I'm thinking of Frank Lloyd, his unique structures. I mean, his estate could probably still do something about it, but I don't know for sure. But things like that, it's interesting, right?
It's scary.
I, as a lawyer, and you as a lawyer, you don't want to scare your clients. You want them to be able to conduct business and do things. So, we look at what's going on, and we assess the risk. We help mitigate it as much as we can, and then you're basically making a decision to take some risk on to return a profit or not, and hope that no one comes after you because you mitigated as much as you could. But there's always a risk out there. And that's really what the take-home message is for pharma and for anybody else who's in commerce. If you're doing something incorrectly and you're a big enough target, someday, somewhere, someone's probably going to come out of the woodwork and come after you, or not out of the woodwork. It may be a big competitor or another big company or whatever. And that's why you go to a patent attorney or a trademark attorney or a copyright attorney, is to kind of anticipate those things as best as you can without shutting down the business. But that's why it's really important to confer with an attorney. If you want to make money, you better confer with an attorney first to make sure that you're not going to be stopped from making that money or doing good for society, and stopped by somebody, in my perspective, from a intellectual property standpoint, for violating somebody's intellectual property rights. And they're out there, and whether they're being enforced on the internet or not, it's not the criteria, like you said. It's not the fact you only did it 3 times. It's not the fact there's only 8 bars. It's whether or not it falls under the elements of an infringement for copyrights, patents, or trademarks, or what have you. So, or moral rights, or right of publicity, right of privacy, all that.
I love it. We can keep going, obviously. I have 100 other questions, but we're going to let this go at this moment. We have to bring you back, John, and we're going to have some more discussions. Before we go, how can people reach you?
Oh, they can always reach me through my email address, which is john.malgin@stevenslee.com. And they can always reach me there. And I have my V cards there, so they want to download it and put it in their Outlook or put it wherever they save their V cards. And they can also go and onto LinkedIn and find me there as well. Sometimes I'll put on some interesting articles or what have you. So you can also find me there. You can also message me there.
Perfect. John, thank you again for coming on. This was excellent, and we look forward to continue the conversation.
Thank you very much, Darshan. I really appreciate it. I always have fun on your show.
Thank you.
All right. Take care.